Morning, everyone. Welcome to House Judiciary. Finally Friday, and we have 3 bills before us. I like to open every session with this little caveat that in this committee, we treat each other with respect. We maintain decorum in the room. We can disagree vigorously as long as we do so respectfully. If you get out of bounds, I will give you one warning and then we'll have you removed from the room if you persist. So amazingly, we just don't have that problem in this committee. We get started on the right foot and we stay there. So appreciate everybody being here this morning and lay out the ground rules. Can we call the roll, please?
Representative Brady,
Here.
Representative Bratton,
Here.
Representative Chesnick,
Here.
Representative Filer,
Excuse, he's in a committee across the hall.
Representative Kelly.
Is he zoomed in?
No, he's not here.
He'll be excused.
Representative Lean,
Here.
Representative Singh,
Here.
Representative Webb,
Here.
Chairman Washut.
Here.
You have a quorum.
All right, our first bill for consideration this morning is House Bill 66. Representative Co-Chair, Vice Chair, whatever title we want to use this morning. Vice Chair Singh, why don't you walk us through your bill?
Thank you, Mr. Chairman, and good morning, everyone. I realize I'm the start of your Friday today, and so I want to be expeditious with our time. It's very important. So I present to you House Bill 66. This is, I bring this bill to you out of reflection from the different issues that we faced as an interim committee. There were 2 primary issues that we faced. It was the fact that I believe the people want the judicial system to remain independent from any other branch of government. That was something that we heard as we were discussing other potential agenda items during the interim. That was something that was said loud and clear, that the judiciary needs to remain independent. At the same time, something else that was said loud and clear was that the executive branch needs to back off, that the executive branch has the ability to push their thumb on the scales in a way that's unfair and frankly separates the division of powers that we have, the separation of powers. And so this bill is an attempt to hit 2 birds with 1 stone, to simultaneously reinforce judicial independence while also separating that branch of government from the executive branch. And also, as an unintended consequence, well, perhaps as a consequence, it would make the legislative findings that we have here in the legislature much more impactful and important for the discussion of any bill that comes before the judiciary. And so with that, it's a short little bill. It's only 4 pages long. It doesn't have a fiscal note. And the 4th page is just that it's effective July 1st. And so really the meat of the bill is in 16.3.114, impacting judicial review of agency actions. And so you can find that really the new language is on the bottom of page 2 and the top of page 3. And so it will strike the language. If you look at line 7 on page 2, it strikes the rules adopted by the Supreme Court under this provision may supersede existing statutory provisions. And on page 17 and 18, or I'm sorry, line 17 and 18, it says, and due account shall be taken of the rule of prejudicial error. And it introduces the 2 new paragraphs starting at line 21 of page 2 and then going on to page 3, ending at line 9. And so in interpreting a state statute, rule, regulation, or other sub-regulatory document, the reviewing court shall not defer to a state agency's interpretation of the statute, rule, regulation, or final decision, and shall instead interpret the meaning of the statute, rule, regulation, or final decision and effect de novo. And de novo, that's a Latin term. I'm working on my languages. And so de novo essentially means a fresh set of eyes, that it's being done new. And so I believe that's a foundational principle to our justice system, that we look at things blindly. Justice is blind, and not in the sense of that we're not unaware, but that what is right and wrong deserves absolute observance. And so then on line 5 in section E, in actions brought under this section by or against state agencies, after applying all customary tools of interpretation, the reviewing court shall exercise any remaining doubt in favor of a reasonable interpretation that limits agency power and maximizes individual liberty. And I think that's super important. The individual liberty part of this is essential to this bill. We are made up of individuals. If we don't have individual rights, we don't have any rights at all. And I believe that this bill will perpetuate Wyoming's already established reputation of being the state for individual rights. And so with that, I stand for any questions. I know we have some folks that may be interested in speaking about this, but that's my heart in this this bill, is to strengthen the independence of the judicial branch and restore the separation of powers. Thank you, Mr. Chairman.
Thank you for that, Mr. Vice Chair. Questions for the presenter? Representative Shustak.
Thank you, Mr. Chairman, and thank you, Representative Singh, for bringing this bill to us. I'm wondering if, I'll have a lot more to say about this when we get to working the bill, but are you concerned that this bill is amending the Administrative Procedures Act, right? Which applies only to certain kinds of cases. It only applies when an agency has made a determination and the person, individual who doesn't like the determination of whatever the agency is, has a right to have another set of eyes look at it, which is going to be a court. And the Administrative Procedures Act is the method by which that case gets heard de novo. And they are being heard de novo by default. But so this rule only applies to those kinds of cases. Is the intent of the bill to go beyond agency appeals, or are you okay with limiting this? I mean, the way the bill is worded, it only is limited to just simply agency appeals. Are you trying to go beyond that or not? Or what is the intent of the bill?
Vice Chairman Singh.
Thank you, Mr. Chairman, Representative Shustak. And to be clear, just before I proceed, I understand that everyone involved in the judiciary system looks at things with all the tools presented to them, and that their judgment is that they look at things in a system that is reflective of what they know is right and wrong, and that it's not weighed inappropriately by any sort of outside source. And so I will advocate for the integrity of our justice system as it stands right now. And de novo review is widely practiced as a tradition within the justice system here. What my bill aims to do is to codify that. And if it's limited in scope, then I think it's more important to get something written down as it applies to these specific cases. And then if we, particularly as a committee, if we choose to explore expanding that to other cases, then that would be appropriate in a different bill.
Yep. Any further questions? Representative Singh. So when I read this bill, it seems like we switch. We go from having a thumb on the scale on a Chevron type standard where the agency is given deference to having a thumb on the scale that the other party has deference. What would be wrong with just leaving neither party having any deference and letting the court work through the facts with the tools they have?
Thank you, Mr. Chairman. So this particularly removes the unnecessary influence of the executive branch on the cases affected. And so I would trust the judicial branch of government to be able to look at the case itself and the facts that are presented in whatever case that they're talking about. And this gives power back to the judiciary to make that decision in an unbiased way.
Okay. Anyone else? Representative Ling.
Thank you, Mr. Chairman. Thank you for presenting your bill today. I have a question about page 2, lines 7 to 9, where we strike the rules adopted by the Supreme Court under this provision may supersede existing statutory provisions. And I was just wondering if you could speak to why you wanted to strike that overall.
Representative Ling. Or Representative Singh.
Thank you, Mr. Chairman. Really, this is to revise the rules for review for the judicial branch. And so this gives that independence to the judicial branch. And in order to accomplish that, we needed to remove that language.
Follow up.
Thank you, Mr. Chairman. Thank you for that. So my question is there a goal here to have the courts practice just one kind of law? So there's textualism, originalism, judicial restraint, judicial activism, the living constitution. And right now our justices have the ability to use any of those while interpreting a case. And I'm curious if this may limit one of those.
Representative Singh.
Thank you, Mr. Chairman. Representative Lean, I would say that this bill instead of limiting the judges and what they're able to do and the judgment that they're able to cast, this enables them to rely upon their own intuition. Instead of deferring to an executive agency, this allows them to make the choices that they need to in order to come to justice in whatever case that they may be addressing.
So Representative, when the legislative branch intervenes and dictates that the Supreme Court's rules don't apply in a particular situation, how is that not a separation of powers concern?
I'm sorry, Mr. Chairman, can you repeat that?
So by striking that language on line 7 through 9 on page 2, we're basically saying that the Supreme Court's rules aren't to be applied, right? Previously that was in the statute. Now we're taking it out of the statute. Does that not create a separation of powers problem?
Mr. Chairman, I would say no, that by removing this language, it actually takes away restrictions in how the court may decide to proceed.
Representative Chester.
Thank you, Mr. Chairman. I'd like to, kind of following up on your earlier question about the thumb in the scale and which side do we want to give benefit to. I think we need to clear up a misconception here that this, as I said before, this bill amends the Administrative Procedures Act, which is how an individual can appeal a decision made by an agency. So the agency is a party to this appeal. They're not going to, there's no rule of law that says the agency should win. I don't think that's what, so if there's an appeal, the agency is being appealed. They're party to this, to this review. Shouldn't we be talking more about burden of proof? Does the agency have the burden to prove that its action was correct? Or does the individual filing the appeal have the burden to say the agency was incorrect? That's, I think, where the action really should be, because the agency's interpretation is that's the issue to be decided in the case. So I guess I would really much prefer to have this bill talk about burden of proof in an appeal. Who has the burden to go forward with the evidence, and who has the burden to persuade the court as to whether the action was correct or not correct? Do you have any reaction?
Representative Singh.
Thank you, Mr. Chairman. Representative Chestik. Well, I would say that if the agency in question is a party in the case, then it becomes even more important for the judicial branch to look at it from a neutral perspective without having them weigh in.
Representative Singh, do you have some case citations of situations in Wyoming where the Wyoming courts have actually given deference to an agency in a manner that you think is improper?
Thank you, Mr. Chairman. I did not bring this bill in a retaliatory effort against the judicial system in any way. And so I'm not bringing this in response to any particular court case.
Other? Thank you very much. Do you have other witnesses in the room that you have arranged for? Mr. Lindholm. Welcome to House Judiciary. We don't see you very often.
Thank you, Mr. Chairman. Your committee scares me, so I tend to stay with like corporations and minerals. Mr. Chairman, my name is Tyler Lindholm. I'm the State Director for Americans for Prosperity here in the Cowboy State. And I really appreciate this bill being brought forward. We're on and in favor of it. And our reasoning behind, Mr. Chairman, actually has to do with Wyoming decisions. All of this stems from the fact that Loper Bright did happen. Chevron deference is gone now at the U.S. level. Fantastic news, in my organization's opinion. So what we started to do is we looked at Wyoming cases, and what we found was that actually Wyoming was kind of a hodgepodge as far as agency interpretation, whether the state courts, even the Wyoming Supreme Court, was providing agency deference. And immediately tipping that deference towards them on their interpretation. And indeed, we did find some. As an example, Mr. Chairman, ExxonMobil Corporation versus the Wyoming Department of Revenue in 2009. It was a tax dispute. ExxonMobil challenged the Department of Revenue's interpretation of Wyoming tax statutes regarding valuation and taxation of natural gas production. The Wyoming Supreme Court explicitly stated that an agency's interpretation of the statutory language which the agency normally implements is entitled to deference. And Mr. Chairman, the important part of this legislation is de novo, as Representative Chestek mentioned. That de novo is utilized quite a bit throughout law. He's an expert in that situation, and that's all this legislation explicitly does, is essentially says, read it as it is written. Mr. Chairman, there was some talk about thumb on the scale, and I don't disagree with that sentiment. The executive currently, with agency deference, as stated by the Wyoming Supreme Court, absolutely has their thumb on the scale. So what does this look like all of a sudden if agency deference is no longer there? Well, it's judicial deference at that point. And, you know, kind of in a side way, by you being the legislative branch that wrote the legislation through you. So be careful what you put in statute, number one, but number two, we're giving more power back to the judicial branch where it belongs in interpreting these cases. And so that's why we're on and in favor of this legislation, because we don't believe that agency deference should exist when it is the people versus the state in those regards.
Mr. Lindholm, the language on page 2, line 7 through 9, where we're striking the language about the Supreme Court rules. Do you not see that as a separation of powers concern?
Mr. Chairman, members of the committee, I do not, specifically because the language that stands out the most in that situation is the may. By striking out that sentence, you're removing that may also. They still have the authority to do so due to the fact that that line was just a may in the first place. It doesn't take any other authority away the way I see it, Mr. Chairman and members of the committee.
It would seem that puts the statutory provisions above any option to even consider the rules of the court.
Mr. Chairman, I guess I'm viewing it differently, where I believe that language is inhibiting them. By removing that, it's no longer in statute.
Okay, if you remove it, it's no longer in statute. I get that part. Yeah. Okay. Other questions? Representative Chestek.
Thank you, Mr. Chairman, and thank you, Mr. Lindholm, for being here. I apologize in advance. I can't suppress the law professor in me. And so I'm going to ask you to recite the case. Can you tell me what the facts of ExxonMobil were and what was the issue to be decided in that case?
Mr. Chairman, members of the committee, to Representative Chestek. the deference allowed the department to apply a broader or more aggressive valuation method was essentially the aspect behind it. It resulted in a higher tax liability for the company. Critics of that deference, there was obvious harm to economic liberty in that regard. There's several. This was a quick search, Mr. Chairman, members of the committee, where state court, whether it was the Supreme Court or district, did specifically cite agency deference. Olheiser versus state, that was 1994, and that had to do with workers' compensation. Also, again, Mr. Chairman, members of the committee, Chevron USA Incorporated versus State Board of Equalization, 1996. And this is all just a quick search. I can provide dozens. But, Mr. Chairman, members of the committee, there are also decisions where the court specifically stated they shall not give deference to agencies. And so that's really the situation at play here. Where's a standard that the people can rely on when you have court decisions that are being cited that specifically do give agency deference, and then in another decision they're saying you shall not do this. And so, Mr. Chairman, members of the committee, that's why we support this legislation.
Representative Cheswick.
So there was I'm still not sure I understand the facts of the case. The Department of Revenue issued some kind of a rule that resulted in a higher valuation. Did the court find that the rule was ambiguous?
Mr. Chairman? Mr. Chairman, to Representative Cheswick's question, the way I'm reading this law, no. The way I'm reading this case, no, Mr. Chairman. To Representative Cheswick's question, they specifically cited that an agency's interpretation of the statutory language which the agency normally implements is entitled to deference. They took the side of the Wyoming Department of Revenue based on the interpretation, not based on the law.
Follow up.
I'm not sure how far I should go with this because we have other business to get to, but what was the ambiguity that the court had to resolve in that case?
Mr. Lindholm.
Yeah, thank you, Mr. Chairman. To Representative Cheswick's question, it was ambiguity between what was actually in statute versus what the rules that were implemented by the agency and their interpretation. That was what ExxonMobil in this case challenged. That there was a difference between the agency interpretation and how they proposed their rules versus how the actual statute read. And that deference was given towards the agency.
Representative Cheswick.
I don't want to pursue this too far because we have other business. So was the question in the case whether the regulations adopted by the Department of Revenue were in conflict with the statute or in agreement with the statute? Was that the issue?
Mr. Lindholm.
Mr. Chairman, Representative, without reading the whole case, I'm assuming that it was in conflict, but I can't say for certain. Also,
Committee,
Mr. Chairman,
any further
members of the committee, I am not an attorney. I have a high school degree from Sundance High School. Go Bulldogs.
Well done.
Thank you.
Further questions? Seeing none, thank you for being here, Mr. Lindholm.
Thank you, Mr. Chairman.
Anyone else in the room wishing to testify on House Bill 66? Anybody on Zoom? Representative Singh, some parting comments?
Thank you, Mr. Chairman and members of the committee. This, in my opinion, is a nice, simple, sweet bill that can hit two birds with one stone. And so I am definitely open to making it a better bill. And if there are amendments, I would love to have that conversation. But in the meantime, I think this is great policy for the state of Wyoming, and I would encourage an aye. Thank you.
Thank you very much. You want to come up, take your seat? All right, committee, any amendments to the bill? Representative Cheswick.
Thank you, Mr. Chairman.
One moment. Officially close public comment. Now we go to amendment.
Okay.
Committee, what's your preference?
Mr. Chairman,
Mr. Vice Chair.
I would like to move this bill.
Imagine that. Is there a second? Second by Representative Bratton. Do we have a motion and a second? Amendments, Representative Chestic.
Thank you, Mr. Chairman. I have several amendments I want to propose with, I may still vote against the bill because I think it's unnecessary. It doesn't do what I think the intent is. But my first comment, I need to explain a little bit about what the bill does, and that'll explain why I want to make some of these amendments. As I was indicating earlier in my conversation with Representative Singh, this bill is an amendment to the Administrative Procedures Act. The APA is a device to protect individuals. It's already designed to protect individuals who have been subjected to some decision by an administrative agency. And there's any number of administrative agencies, Department of Revenue, Department of Family Services, Department of Health, lots of rights that people have that they have to go to the government to get implemented. And if a person is aggrieved by a decision by an administrative agency, they didn't get the benefits they wanted, or they didn't get as much as they wanted, or there's some problem that they want to try and redress, the APA provides a remedy to court. It's court review of an administrative agency. That's all that the APA does. It does not really deal with general questions of statutory interpretation. But in any kind of an administrative appeal, if you're going to have the court review it, what is the court reviewing? There's not a formal record. There's not a transcript of a trial. There's not evidence. It's because it wasn't a court proceeding below. There's a debate about what are they reviewing. So the APA provides a procedure to allow the court to determine what the record is, and it needs some clarity, it needs to have a record to review. And so it's given, the court is given some broad authority to determine what is relevant information for them to be able to review the decisions made by the administrative agency. And that leads to my first amendment, which gets to the language that the good chairman was concerned about earlier on page 2, lines 7 through 9. That language allows the court to determine what it needs to see to make a good decision, an appropriate decision. And by taking that language out, when you remove language, that's legislative history that says we intend to do something, we're intended to change something. So when the language exists that says the court has permission, we remove that, the Supreme Court is going to have to say, well, you took away permission, therefore you no longer have permission to do that. So I think we need to leave that language intact so that the reviewing court, and these would be trial courts, district court typically, they need the ability to determine what information they need to make a good decision in this administrative appeal. So my amendment is to restore to the bill lines 7, 8, and 9.
Is there a second? I'll second it. Discussion on the amendment?
Mr. Chairman.
Mr. Vice Chair.
Thank you, Mr. Chairman. I think by not removing this language, we limit the court's ability to make that interpretation on their own 2 feet. So I would ask that we vote no on this amendment.
Further discussion? So my comment would be that the word may, which you pointed out, is important here, right? The rules adopted by the Supreme Court under this provision may, at the court's discretion, supersede existing statutory provisions. I get the idea that it sounds like we're giving the court the ability to thumb their nose at the legislature, but I think Representative Chestic is accurate that what it does in these proceedings is allow the court to use its rules to get at the facts that need to be brought before the court. And while I don't have expertise in these types of administrative appeals, the permissive language, I think, is important here with the may, that if the court were saying the court's rules shall always supersede statutory provisions, I think that would be equally problematic. But being permissive, where it allows the court, under the circumstances of an individual case, to supersede the statutory provisions, and I'm not exactly sure which statutory provisions would be in play in a particular case. But to me, that sounds important, that the court would have that flexibility. Others? Do you have the amendment to reinsert the language that was stricken on 7 through 9 on page 2? That's what we're voting on. All in favor of the amendment, say aye.
Aye.
Aye. Those opposed, no.
No.
That amendment has failed. Further amendments, Representative Shostak?
Yes, thank you, Mr. Chairman. Also on page 2, the strike of the language on line 17 to 17 and 18. Again, this is mostly a separation of powers issue. The rule of prejudicial error, there's another rule that says the rule of harmless error. These are standards that the court uses to determine whether or not the problem is severe enough to warrant a remedy. These are well-established principles. They don't favor either side, really. And therefore, I would recommend, I move to restore the language stricken from line 17 and 18.
Is there a second? I will second. Discussion. I just caution that as non-lawyers, if we don't fully appreciate the significance of something like the rule of prejudicial error, I imagine if we ask most of us on this panel to articulate what exactly the rule of prejudicial error pertains to or how it works, most of us could not do that. And so I'm hesitant to strike that from existing statute without something in the record to suggest that that really is problematic in the operation of our system, or that it's absolutely necessary to get rid of the deference issue, which I think is at the heart of the bill. Further discussion on the amendment? Seeing none, all those in favor of Representative Shostak's amendment to reinsert the stricken language line 17 and 18, page 2, say aye.
Aye.
Aye. Those opposed, no.
No.
That amendment has failed as well. Further amendments, Representative Shostak.
Thank you, Mr. Chairman. This is my main amendment. I have another one after this, but my major amendment is on line page 2, line 21, starting section D, over to page 3 on line 3. Basically, I want to strike that language and replace it with a single sentence: the court shall review the decision of the agency de novo. Which I think is the main point of what the bringer of the bill is trying to do. And I'm okay with that. That's what happens right now. It's the actual standard that is being applied. If we put in statute, that doesn't change anything. I'm totally okay with putting that in statute. I want to take out the language, though, the rest of the language, because it's highly confusing. It can be misinterpreted. And I think this gets to the heart of the problem with this bill. And that is the bill being placed in the Administrative Procedures Act is very limited. It applies only to agency review of agency decisions. But this language is, I think, intended and may be misinterpreted by others to apply more broadly to statutory interpretation in any other case. I think that is possibly what the intent of the bill, of this language is. It doesn't accomplish that because of its placement in the Administrative Procedures Act. So to avoid further confusion, I think we need to strike all that language and restore it to the court shall review the decision of the agency de novo. That's my motion.
Is there a second? Is there a second? Motion dies for lack of second. Further amendments? Representative Chester.
And this is mostly just a clarifying language on page 3, line 5 and 6. Again, trying to clarify that because this bill is amending the Administrative Procedures Act, which talks about agency reviews, not actions. And action seems like the plaintiff is bringing a new lawsuit. This is not that. This is a review of an agency decision. I just want to change the language, strike the words actions brought and replace that with reviews. And then because the agency is not going to, can't ask for a review of its own decision. The only people who are going to be asking for a review of a decision are the parties affected by that decision. Strike out the words on line 5, by or, and then on line 6, against state agencies. So the final language would read, in reviews under this section, after applying all customary tools of interpretation, then the rest of it stays. That's my motion.
All right, so we're clear. We're striking the words actions brought on line 5, page 3, and replacing that with reviews. And then we're striking the language by or on line 5. So we'll read, Representative Chester, you want to read it as it will read in the revised?
Yeah. In reviews under this section, comma, after applying all customary tools, and the rest of it continues on.
Okay, so we're also striking against state
Yeah,
agencies
right,
on line
yes,
6.
because this agency can't file an appeal of its own decision.
Absolutely true. Got that, Pierre? Okay, committee, we all clear? Discussion on the amendment? Do we have a second on the amendment? I'll second it. Is there any discussion on the amendment?
Mr. Chairman.
Mr. Vice Chair.
Thank you, Mr. Chairman and Representative Chestick for bringing this amendment. I would have to think about the further ramifications of this amendment before tagging it on to the bill. And I'm not saying that it's a good or bad. I would need to review this amendment a little bit further. And so perhaps we could bring it on as a committee of the whole amendment. But in the meantime, I guess I would say, please vote no.
Representative Singh, will that review be de novo?
Mr. Chairman, yes.
All right. Any further discussion on the amendment? Seeing none, all those in favor of Representative Chestick's amendment pertaining to lines 5 through 6 on page 3, say aye.
Aye.
Aye. Those opposed, no.
No.
That amendment has failed as well. Further amendments? Seeing none, let's call the roll.
This is a roll call vote for House Bill 66. Representative Brady,
Aye.
Representative Breton,
Aye.
Representative Chestick,
No.
Representative Filer,
He left a vote of aye.
Representative Kelly,
Excused.
Representative Lean,
Aye.
Representative Singh,
Aye.
Representative Webb,
Aye.
Chairman Washet.
Aye.
I have 7 ayes, 1 no, 1 excused.
Very good. Representative Singh, you'll be presenting your bill on the floor.
Thank you, Mr. Chairman. And if there are any amendments that come on the floor, I'd be happy to work them through.
Very good. All right. Mr. Vice Chair, you have the gavel.
Thank you, Mr. Chairman. Alrighty, folks. So the next bill for our consideration is House Joint Resolution number 5. And for a presentation of this resolution, we have Chairman Washit. Please.
Thank you, Mr. Vice Chairman. Pleasure to be here in front of the committee. It always feels a little odd sitting in this side of the dais. I don't think this is going to be a really time-consuming piece of legislation. House Joint Resolution 5 is a non-binding resolution by the legislature, type of thing we issue from time to time, calling upon others to act in a way that we desire, but which we really don't have clear authority to command, right? So we use a resolution of endorsement or support. And so this is an interesting case. We could easily spend hours. Literally, there's been a book, and a witness who's in the room has written a very extensive critique of this legal proceeding that took place back in 1978, I think it was. But I don't think it's necessary for the purpose of this resolution to go into the nitty-gritty of what took place in this case. But a general summary is we have a Wyoming peace officer working undercover for a Wyoming law enforcement agency. At the same time, the state of Wyoming has convened a statewide grand jury to investigate allegations of corruption in that municipality. The undercover officer is subpoenaed to give testimony at that grand jury, which sends, I think it's fair to say, shockwaves through the community, certainly through the police department. The officer is in the city at the time that there were 3 ranking members of the police department in a police vehicle in the parking lot outside of a bar. They summoned the officer to meet with them in the police vehicle in the parking lot. In very short amount of time after that, officer sits into the back seat, passenger side or driver side of the car. One of the law enforcement people in that vehicle sitting in the front passenger seat pivots across the seat and shoots the officer dead in the back seat. The vehicle is then moved, driven across the street over a curb to get out of a bar parking lot, which might be problematic, I suppose. And then other responding officers come to the scene, and the investigation unfolds. What this resolution is about is that in the aftermath, with all that was going on in that community at the time, the individual is charged with murder. There's a 15-day preliminary hearing in the courts in that county, after which the individual is bound over for trial on a finding that there's probable cause to believe the individual had murdered the police officer, Michael Rosa. The case goes to trial. The charged individual is represented by one of the most talented trial attorneys in the state of Wyoming at the time. And after the trial, the jury returns a verdict of reasonable doubt, and the man is not convicted of that murder. Okay. Subsequent to that, 1986, the Wyoming law enforcement community establishes a memorial wall at the Law Enforcement Academy in Douglas. And they went back in history and identified officers who had been killed in the territory of Wyoming or in the state of Wyoming as far back as they could determine. And those names were enshrined on the memorial wall. Officer Rose's name was not included. So that was 8 years after his death that he is not included on the wall. It's been a long time, and this resolution calls upon the Memorial Committee to include Officer Rose's name on the Wyoming Law Enforcement Memorial Wall. There is precedent for a similar case, although the facts are different. We had a deputy sheriff in Natrona County back in the Prohibition days who was shot and killed during a warrant execution on possession of stolen alcohol from a railroad car. That deputy died from the wounds that he sustained during that execution of the warrant. The case went to trial. There was a change of venue. The case was tried in Converse County, and the alleged shooters were acquitted. That deputy has his name on the Wyoming Law Enforcement Memorial Wall. I'll also add that Officer Rose's name is included on the National Law Enforcement Officers Memorial Wall in Washington, D.C. There's also a major Officer Down Memorial page, which is a virtual rendition, if you will, of a National Law Enforcement Memorial. And Officer Rose's name is included there as well. But in his home state, where the crime occurred, the alleged crime occurred, where his death occurred, his name is not enshrined on our wall. So this resolution calls upon the Memorial Committee to place his name on the wall. Again, we don't have the authority to command that they do that, but we send a message that we think that it would be right and just for that to occur. And that's the purpose of this resolution. I'll take questions. I also have a witness here who is the lead investigator in the case. I would encourage the committee, as fascinating as this case is, we could spend hours that we probably don't have this morning looking at some of the details of that case. But with that, I'll stand for questions.
Thank you, Representative Washington. Any questions for the representative? No questions? Well, I'd just like to say that I am 29 years old, and the thought of having to leave behind a family as a result of a crazy situation, it's tough for me to fathom that. And so the gravity of the situation that you brought before us is not missed there's such a heaviness to the situation. Can you, on the floor for introduction, there was a particular statement made about this individual, and it caused me to have some second thoughts about the introduction of that, and that's why I voted against the introduction. Do you want to explain some of that, Mr. Representative?
Certainly. Thank you, Mr. Chairman. So the defense at trial was self-defense. And there was the defense suggested that the officer in the back seat of the police car, Officer Rosa, who was killed, was in fact going for his gun and was outdrawn by the officer in the front seat. But there are some facts that caused me concern with that rendition, and I think you'll hear from the investigating officer as well. Part of it was that when Officer Rosa came out to the car, there was a police officer in the car seated in the passenger side rear seat that was nearest to the approach of Officer Rosa. And that officer began to scoot across the back seat to allow Officer Rosa to sit where he was seated. And the man who was charged with this crime tells him, "Stay where you are." Okay, which puts Officer Rosa in a particular seat in the vehicle. You know, why would you do that, right? But none of us will have 100% certainty what took place in that car. But the fact that Officer Rosa had been subpoenaed to testify about corruption had certainly created an atmosphere that was scaring people within that city about what he might say, who might get implicated. And without getting too far off in the weeds, there had been a prosecution of another individual in the state pursuant to this grand jury for a very minor travel voucher discrepancy. And that individual had been convicted, which added to the fear that this grand jury was going after anything and everything, right, that may have been a problem. So I really, a lot of people will tell you that Officer Rosa was a very brash individual. He wasn't a Wyoming native. He came here from out of state, which is part of what made him a very effective undercover officer, was that he wasn't a Wyoming guy. He carried himself differently. He behaved differently. So this is not a matter about his personality or any of those sorts of things, but it is a matter that as we look back almost 50 years almost now, for him to be listed on the National Memorial Wall and left off of the Wyoming Memorial Wall seems to an injustice. And I hope that this resolution will help remedy that. And I think if you hear from the next witness, you'll come away with a good impression.
Thank you, Mr. Representative. Any other questions for the representative? Seeing none, thank you. Welcome. Please state your name for the record.
Try it again.
And you can call me that or something worse after I talk if you want to. Trying not to get too far into the weeds, as Chairman Washut said, with the details of this, I would like to say that I am very much in favor of this. I think this is an old injustice that needs to be corrected. And so I support the resolution. It might be helpful for me to tell you a little bit about who I am and how I got involved in this case. And in fact, this grand jury that started this chain of events is what got me a job with the Division of Criminal Investigation in the Wyoming Attorney General's office. I'm a native of Wyoming. I've lived here most of my life, all of my life, except for about 5 years I spent in the Army. I am a graduate of the University of Wyoming with a bachelor's degree and also a law degree later on. I studied criminology at the University of California in Berkeley for 1 semester, and that put me a semester behind over at UW. So I graduated in January of 1965. I had been in the ROTC program, so I got an Army commission in the Army Infantry and entered the Army then and went to Fort Benning for training as an infantry lieutenant and parachute and ranger training. And that spring, I went as a platoon leader with the 82nd Airborne Division to the Dominican Republic. There had been a Cuban-inspired communist revolution down there, and Lyndon Johnson sent us down to set things straight. That was kind of a short war. We were home by New Year's in time for a big New Year's party. And then a few months later, I went to Vietnam and spent a year there. I was discharged as a captain in 1969. I spent 2 years teaching school in the junior high school at Laramie. And then I went to UW Law School on the GI Bill, graduating in 1974. In 1978, I was serving as a county judge in Fremont County. And in 77, I actually watched and heard 2 60 Minutes programs. The first one said there was corruption in the government and the police department in Rock Springs. And they showed some grainy pictures they said there were prostitutes everywhere, and they showed some grainy pictures of women who appeared to be leaning in the windows of cars on the street on K Street. And the allegation was that these were prostitutes soliciting business. And the allegation was further made that the police department was looking the other way in exchange for free sexual favors. A week later, there was another program, also on 60 Minutes, that accused Governor Herschler of being corrupt with other officials in Sweetwater County, including Don Anselmi, who was at that time was the chairman of the Democratic Committee of Wyoming. And this caused needless to say, a flurry of activity. The second program, the primary witness was a man named Neil Compton, who had been appointed as the director of the Division of Criminal Investigation, DCI. As you probably know, when Wyoming legislature passed the Controlled Substance Act in 1971, it authorized the Attorney General to hire investigators, and he had been hired under that authority. Then in 73, the legislature passed another law that formalized that a little bit and created the DCI as a division of the Attorney General's office. Anyway, Neil Compton was the director, and he said on the 60 Minutes program that Governor Herschler was corrupt. And these other people, he offered absolutely no evidence of that, and I never saw any evidence in the time I was in that office. But he said that he was convinced that if there was a grand jury, they could find some evidence. So Governor Herschler responded by firing Compton and some other people that had testified or that had talked on the 60 Minutes program, and convened a statewide grand jury to investigate these allegations. And then they started recruiting for a new director of DCI, convened a panel of chiefs and sheriffs to select a new director. I had some experience with a district judge named Robert Rank, who was based in Jackson, but he worked in Lander because that was part of the 9th Judicial District, and he had appointed me a guardian ad litem in a number of juvenile cases, and he and I spent a lot of time in his office talking about those kids and their families and so forth, and kind of developed a personal relationship. He knew, because I had told him that when I got out of the Army, I tried to join the FBI and I couldn't pass their vision test, which I thought was kind of stupid because I'd been in a paratrooper and a ranger and in 2 wars with my glasses, and that worked just fine. I just carried extra glasses. Anyway, Judge Rank encouraged me to apply for this vacant position with DCI. And I said, I don't have any law enforcement experience. I'm not qualified. And he said, one of his favorite expletives that's abbreviated PS, he said, you're way better qualified than that idiot they just fired. So anyway, I sent in a resume, and he said he would call Governor Herschler, and he did. I didn't get the director's job, but they selected a retired major from the New York State Police. But they appointed me as his assistant and made me a special assistant attorney general, and announced that my job was to ensure that the division acted legally and morally. So in that position, later on, I attended the Wyoming Law Enforcement Academy and also the FBI National Academy, and was certified as a peace officer in Wyoming. But in that position with DCI, we got a call in the middle of the night on July 15th of 1978 that a police officer had been killed in a police car and by a police officer in Rock Springs, and we were asked to come and investigate it because they needed an outside agency to be impartial. Special Agent Bill Olmstead, who was a retired Air Force OSI agent, and I were sent by the director. The director said this looked like it had political ramifications, and he wanted me to be there. And that was an understatement. It became a circus, to say the least. It's a long and complex story to explain the investigation and the month-long trial of the person, but the alleged killer was the director of public safety at Rock Springs. After this 60 Minutes program, they had hired him to clean up what was alleged to be a mess there. They had an old-time police chief that had been there. I'm not sure there was corruption, but what there was an energy boom with the power plant being built there, and the Trona mines, and lots of energy development, and a lot of highly paid young men in town that were looking for trouble and had a lot of money to spend. And I think they just weren't dealing with it very well. And I'm not sure that's corruption so much as just what was going on. But anyway, the precipitating events of the killing, I think, need to be explained just a little bit to put it into context. I'll try not to get too far into the weeds with this, but a lot of people, that was the beginning of the war on drugs with the adoption of the Controlled Substances Acts, and local governments were struggling with the how to pay for this enforcement, drug enforcement. There was undercover people needed to be paid. They needed to pay expenses, sometimes buy drugs. And in this particular case, Mike Rosa rented an apartment. He lived in a trailer house there in Rock Springs with his wife and 2 or 3 kids. And he had an apartment where he did his drug transactions, and all of this cost money. So the Rock Springs City Council allocated $12,000 in the year's budget for this, and the city clerk or treasurer, being a good bureaucrat, said that means $1,000 a month, no more, no less. And I need to have documentation for it. Of course, you don't get receipts in a drug deal. So what that was Michael Rose's reports of his activities and what he spent on the money on. 1 month prior to the killing, he spent more than $1,000, only $40 more than $1,000. His supervisor, Sergeant Jim Callis, who happened to be the driver of the police car the night that Michael was killed, said, okay, I want you to write 2 reports, one that says what you actually spent, and we'll put that in court in the criminal case. And then I want you to write a second report that says you only spent $1,000 and make up for the $40 next month. The grand jury was desperately looking for corruption in Rock Springs, and they had an investigator who was a young lawyer over there, and somehow he came in contact with Michael Rosa, and Michael Rosa told him about these 2 reports. And this investigator thought, aha, that sounds like corruption, a double set of books in the narcotics fund. So he gave him a subpoena to come testify in the grand jury. Michael, foolishly as it turned out, told one of his friends about that, and that he planned to tell the grand jury about this event, this situation. That friend knew Ed Cantrell, the chief of police, and he called him and told him about it. That started a day-long odyssey in which Sergeant Jim Callis, Sergeant Matt Bider, who eventually became chief of police in Rock Springs, and Mr. Cantrell were driving around looking for Rosa and wanting to talk to him about this. At one point, Jim Callis went to see the mayor, who was an accountant, Paul Wataha, and he said, this is no big deal. It can be explained. Don't worry about it. Stay away from him. He's a grand jury witness under subpoena. Don't talk to him. Don't do anything. And unfortunately, they didn't follow that advice. Cantrell insisted that they find him, and at one point made a statement, maybe we ought to take the son of a bitch out and kill him. And they found his car in the parking lot of a bar in Rock Springs, called a police dispatcher and told her to telephone the bar and have them send Michael out to talk to them in the car in the parking lot. He came out, and there was a very brief interaction between him and the other people in the car that resulted in one gunshot being fired between his eyes and killing him instantly. So the common perception was that he was killed to keep him from telling the grand jury about corruption in Rock Springs, but in fact, that's all he knew was that $40 bookkeeping error. And I don't know whether you want to call that corruption. It didn't sound like corruption to me. It was just a stupid way to correct a simple mistake or a simple situation. So the prosecutors, I think, maybe naively considering the reputation of the defense lawyer that ultimately got involved in the case, thought they had a slam dunk case. They had a man who had threatened to kill this victim, and an hour or so later, he did in fact kill him. But it turned into something much more complicated than that. Later, after I left DCI, I went to work as an assistant U.S. attorney in Lander doing cases on the Indian Reservation, and I went to Iraq for a while. The Justice Department asked me to go there and participate in the program to try to teach the Iraqis the rule of law. And eventually President Obama appointed me U.S. Attorney for Wyoming. So over the course of the rest of my career, I spent about 25 years as a prosecutor I had occasion to look at the transcript of this trial. I'd been excluded from the trial because the defense called me as a witness and had an order that the witnesses could not sit in the courtroom. But I read the transcript and was even more convinced that a horrible injustice had occurred. And I wrote a long analysis of that I couldn't get anybody to publish, but it's in the, I tried to set the record straight and deposited that along with the DCI report and some other things in the American Heritage Center, I think it's called, the teepee looking thing out by the field house. Trying to sort of set the record straight. In any event, based on all of that, I think that this is something that needs to be done, and I'd appreciate your support. I'd be happy to answer any questions you might have.
Thank you, Mr. Crofts. And I mean, before we proceed, I just want to thank you for your service to this country, both in your military capacity as well as a U.S. attorney. That is an incredible honor. And I know
Thank
you've
you.
done a lot of great work
Thank you
for our
very much.
state. Are there any questions for Mr. Crofts? Seeing no questions. Oh, Representative Webb.
Thank you, Mr. Chairman. It's not so much of a question as a comment. I too want to commend you for your service. Being a 19-year-old in 1978, raised in Sweetwater County with a family that had been involved in law enforcement, this story has floated around for years. And there's a lot of division, of course, concerning it, which we will never come to complete agreement or resolution with. But I want to thank you for your efforts that you've done. And I remember well Our Town, episode #1, and then High Noon in the capital city.
Yes.
It was #2. And
Yes,
thank
sir.
you.
Thank you.
Thank you, Representative Webb. Are there any other questions or comments to Mr. Crofts? Seeing none, thank you.
Thank you very much.
Do we have any other public comment on this House resolution? Representative Washa, did you have anything else you'd like to say?
Thank you, Mr. Chairman, committee. Not my goal to retry this case or to try to come to some firm conclusion about what exactly took place in that car that day. I don't think we'll ever know. My emphasis here is that a law enforcement officer died in the line of duty. He was summoned to the car, which by his ranking officers, that puts you on duty. You're responding to their summons. And he's been memorialized elsewhere, but not in our state. And that's the goal of this resolution. And I hope that you'll favorably consider it.
Thank you, Representative. Are there any other public comments on this resolution? Any comments from the committee? All right, with that, we will close public comment on this resolution. Committee, what is your pleasure? All right, the bill's been moved by Representative Webb and then seconded by Representative Lean. Is there any discussion on this resolution? Seeing none, I'll go ahead and call the roll.
This is a roll call vote on House Joint Resolution 5. Representative Brady,
Aye.
Representative Breton,
Aye.
Representative Chestek,
Aye.
Representative Filer,
Excused, aye.
Representative Kelly,
Excused.
Representative Lean,
Aye.
Representative Webb,
Aye.
Vice Chair Singh.
Aye.
Chairman Washut.
Aye.
Could you clarify Representative Filer's vote?
He left a vote of aye.
Okay.
This is for 66.
Oh, Oh.
He said over.
Disregard that, Pierre. I'm sorry. That is a
So
excused. Yep.
7 ayes, 2 excused.
All right, that resolution passes, and I think we know who's going to be carrying that on the floor. Mr. Chairman, I'll turn it back to you.
Thank you, Mr. Vice Chairman. Thank you. That takes us through House Bill 10, which is probably why most of you are here this morning. This is a joint committee bill that was worked over the interim, dealing with sexually explicit materials in libraries. Over the interim, we received tremendous amount of input and comment from all across the state. And the bill has been amended significantly in ongoing efforts to try to make the bill workable yet effective. So I think the committee's pretty familiar with the content of the bill. It applies to both school libraries and county public libraries. And the thrust of the bill is to remove sexually explicit material from the juvenile, teen, children's sections of libraries. The bill, as you might remember, that came before us last session included criminal penalties for people who might participate in these things. And that bill didn't make it through the process. We realized as a committee that it needed more work, and so we shelved it. But it was the number one most frequently asked for topic by the Joint Judiciary Committee for an interim topic. Of all the different topics we had to consider over the interim, this one received more votes from committee members than any other. So we took it up. The bill has gone through several iterations. It started off, some of you remember, with $50,000 civil penalties. That's gone. It has been modified in many ways over the course of the summer. One of the concerns that came to us over the summer was that librarians don't know the content of every page of every book in every collection. And so how are they to know whether these materials should remain in their library or not? And so an amendment was made over the interim to include a challenge process whereby if someone were to encounter materials that included some of the graphic sexual content that's identified in the bill as being prohibited, that they would first have to contact a librarian and file a challenge. The library could then review that particular material and determine whether or not it violated the specific language in the statute. And if it did, then the library would have an opportunity to move that material out of the teen children's section of the library, move it to the adult section of the county library, and there would be no legal ramifications. If the book material was determined not to violate the specific descriptions within the statute, it would remain. So what the bill does not do, I think, is equally important. The bill does not ban all books that have any reference to sexual stuff, right? Romantic books, books that talk about sexual encounters without being particularly descriptive are still okay. They would not be touched by this legislation. This bill does not touch innuendo. It doesn't touch anything except for very specific and graphic descriptions or depictions of specified sexual acts. So if those sexual acts are not described in the book is not covered. And the committee has taken some criticism from folks who say the bill doesn't go far enough, that because it is restricted to just those few specified sexual acts, that maybe the bill didn't go far enough. But this is the approach the committee has made thus far with House Bill 10, and that is what is before us today. Anybody on the committee want to add to that intro to the bill? Representative Lean?
Thank you, Mr. Chairman. I just want to say that this bill has come a long ways, and I do believe that it gives the power to the parents. It gives them the authority and the privilege to know what is in the literature that their children are deciding to pick up off the shelves, and that just by reshelving books within a library does not constitute keeping them away from children. Thank you so much.
Okay. With that, I'm going to open up the floor to public comment. We do have a hard stop in 30 minutes. So at 9:45, we're going to stop public testimony and bring the bill before the committee so that we have time to act on the bill before we have to be on the floor at 10 o'clock. I realize that that's not a lot of time, but in a budget session of the legislature, time is not our friend. We were here till 11 o'clock last night, and we were back at it at 8 o'clock this morning. We have received a tremendous amount of public comment on this bill over the summer. I would encourage those in the audience, especially if you have specific language or sections of the bill that you would like to see improved or language deleted, those would be the most helpful comments to receive today, to look specifically at this bill and help us make it better. And with that, what I'd like to do is do we have anybody on Zoom? 4 on Zoom. I want to take testimony first from those. I'll give 15 minutes to those who want to generally be supportive of the bill, who like the idea that we work this bill, and then give 15 minutes to those who are opposed to the bill. If we don't use all 15 minutes and those in favor, then that time will be provided to those opposed. So if there's anybody in the room wanting to speak generally in favor of the bill, please come forward. And please be brief and to the point. Identify yourself for the record.
Thank you, Mr. Chairman, members of the committee. My name is Patricia McCoy, and I'm speaking on behalf of the Moms for Liberty chapters across the state of Wyoming. We are here in strong support of House Bill 10. It establishes clear statewide standards for how sexually explicit materials are handled in both county and school libraries, provides statutory definitions, sets expectations regarding access by minors, and ensures that accountability exists when those standards are not followed. Wyoming has long recognized that minors require different protections than adults. We set age requirements for driving, we restrict access to tobacco and alcohol, and this is no different. House Bill 10 applies the same common sense principle within our publicly funded libraries. This bill brings consistency, it offers workable definitions, it establishes a transparent challenge process, and it ensures that reasonable standards regarding minor access are applied evenly across the state. Protecting childhood has never been about limiting ideas. It has always been about recognizing that children and adults are not the same. And public policy should reflect that reality. Parents deserve transparency, communities deserve clarity, and minors deserve age-appropriate environments, and House Bill 10 does all three of these. We respectfully urge that you support House Bill 10. Thank you.
Thank you, Ms. McCoy. Any questions for Ms. McCoy? Don't see any. Thank you. Anyone else in the room wishing to speak generally in favor of the legislation? Seeing none. Anybody online? Please. Okay, Mr. Lehman, bring Mr. Lehman in. Good morning, Mr. Lehman. Please identify yourself for the record and briefly tell us what you'd like us to know.
Thank you, Mr. Chairman. Deacon Michael Lehman, representing the Catholic Diocese of Cheyenne, and just appreciate the work that was put into this and understanding many of the concerns that folks have raised. I will just say initially, my own experience with this, I was kind of wondering if maybe there was an overreaction, but actually it was an article from one of our online periodicals that put out the content that's available. And quite honestly, I was surprised myself as to what was there. So really appreciate the work that was put into it and support the efforts that have been made so far. With that, I would stand for any questions.
Thank you, Mr. Lehman. Any questions for Mr. Lehman? Appreciate you being here. Anyone else in the room, one more time, who wants to speak generally in favor of the bill? Okay, so we're going to take the remaining time up to about 9:45, which gives us, I think, 26 minutes or 16 minutes, something like 25 minutes. Anyway, who wants to come first? Just know that lots of people want to go after you, so brief and to the point is the watchword of the morning. Please identify yourselves. Make sure you have a green light on your microphone. Speak into the mic so that people online as well as in the room can hear you.
Thank you, Mr. Chair, members of the committee. Appreciate your willingness to listen and consider some of our thoughts. I'm Christine Brady. I am the current president of the Wyoming Library Association. WLA remains steadfastly opposed to this bill and to other bills that restrict access to information. Our stance is simple. Wyoming libraries are for everyone. Our professionals work diligently to place materials in age-appropriate locations, curate collections that meet the needs of every citizen, and treat each patron with respect and dignity. Whether in our most populated hubs or our most frontier areas, Wyoming libraries are essential to building literacy among our children and expanding it among our teens. Wyoming libraries are models of Republican values. We support parental rights by championing parents and guardians' right to choose the best materials for their children. We are examples of local control. The government closest to the people governs best. Wyoming libraries are locally governed, long-standing institutions overseen by local boards. We are a microcosm of checks and balances. For decades, let me repeat that, for decades, libraries have utilized reconsideration and challenge policies inviting the community to weigh in on purchasing and cataloging. We support common sense over government overreach. We believe the power to choose what a child reads should rest with the parents and the parents alone, not the state government. We fight for constitutional integrity. Wyoming libraries defend the U.S. Constitution, the Bill of Rights, and our fundamental right to free speech. Moving a book from the location of its intended audience is censorship. It is vital to be clear what is and is not in our collections. There has been a prevalent narrative that Wyoming libraries contain pornography. Let me be clear. Wyoming libraries do not house pornography in any part of their facility. This legislation does not represent a compromise or a collaborative solution. Rather, it serves a single political narrative. While politics are always shifting, libraries remain in the neutral zone, providing materials that represent all viewpoints regardless of who is in power. While the bill's intent may be to protect children, its unintended consequence will be to harm them by restricting their access to information. It was said, good intentions do not eliminate constitutional trade-offs. History shows that rights are rarely taken by villains. They are eroded by well-meaning people who believe the ends justify the means. In this case, the means is censorship. It is up to you to decide if you will justify censorship. Thank you, and I will stand for any questions.
Thank you. Appreciate you being here. Good morning.
Good morning. Thank you for giving us the time to speak, Chairman and members of the committee. My name is Judy Boyce, and I'm the Assistant Director of Sublette County Library in Pinedale, and I also serve on the Pinedale Town Council. I am here to oppose House Bill 10 because it conflicts with longstanding First Amendment principles and would place Wyoming libraries in direct conflict with constitutional protections that courts have recognized for decades. Public libraries exist to provide access to a broad range of ideas so that individuals, not the government, decide what they read, what they learn, and what they believe. As a parent of 5 children and someone who spent 13 years homeschooling, I believe one of the greatest gifts that we can give our children is the ability to think independently, to pay attention to the topics or controversies that are in the news, and to think for themselves. I want my kids to know that they shouldn't just take the word of someone who is trying to tell them what to believe. They shouldn't trust a single paragraph plucked out of context, which could easily be used to misrepresent the content of a book. Instead, they should read the whole book, think critically about it, and discuss it and the controversy and gain a complete understanding. The U.S. Supreme Court has repeatedly affirmed that the First Amendment protects the right to receive information and that government officials may not suppress ideas simply because they dislike or disagree with them. In other words, the government does not have the right to tell us what to think. In the Board of Education versus PICO, the court held that officials may not remove books simply because they dislike the ideas contained in those books. Federal courts have applied this principle to public libraries as well. In Sund versus the City of Wichita Falls, the court ruled that removing or relocating books based on objection to their themes, specifically LGBTQ-themed children's books, was unconstitutional viewpoint discrimination. In Counts versus Cedarville School District, the court struck down a policy requiring parental permission to access the Harry Potter series because it burdened access based on the disapproval of the ideas in the book. These cases make one thing clear. Government actors cannot restrict access to lawful materials because of disagreement with their content or viewpoint. House Bill 10 attempts to do exactly that. The only category of sexual conduct or content that was unprotected by the First Amendment is obscenity, which is defined narrowly under the Miller test. Public libraries in Wyoming do not collect obscene material. I've heard some of you mention Hustler. Libraries don't have Hustler or things like that. What House Bill 10 would restrict are the materials that are House Bill 10 would restrict the materials that are fully protected speech, including literature, art, health information, and works that reflect the lives of our diverse Wyoming residents. Labeling these materials as pornographic does not change their constitutional status. House Bill 10 would force libraries to treat protected expression as if it were illegal obscenity, placing library staff in the position of violating either state law or the First Amendment. It would also invite costly litigation to our counties and the state because, as I just outlined, courts have consistently struck down laws that burden access to lawful materials based on viewpoint or content. In other words, under House Bill 10, we could be sued for not removing a book, but if we do move it, we could be sued for that as well. Wyoming communities are diverse in their beliefs, their values, and their needs. This is why it's so important to keep decision-making at the local level where we know our people. Public libraries serve everyone, not just those who object to certain books. Parents already have full authority to guide their own children's reading. As librarians, we fully support that authority and encourage parents to be involved in what their children are checking out. House Bill 10 would create a situation where random community members could restrict what your family could access, which is a form of government overreach that courts have repeatedly rejected. Lest you think that requiring libraries to move items to the adult section would not be classified as censorship, I would just reiterate that in the case of Counts versus Cedarville School District, the courts determined that moving the books was unconstitutional viewpoint discrimination, even if they were keeping the books in the library to be accessed with permission. For these reasons, I respectfully urge you to oppose House Bill 10. It is unnecessary, it is unconstitutional, and it's harmful to the freedom of Wyoming residents who want to learn and read for themselves. And making a bad bill better doesn't necessarily make it a good bill. Thank you for your time.
Thank you very much. Others in the room? Again, we've got about 15 minutes left and lots of people in the room. Please keep your comments to point. Who's going first?
Honorable Chair, members of the Judicial Committee, my name is Mary Cockett. I'm an Episcopal priest from Cody, Wyoming, and I speak in opposition to House Bill 10. And at the end of my remarks in support of my local library, I do not offer an amendment, but a suggestion on the way to trying to make this a better bill. I speak in opposition to this bill because I see it as a sneak attempt to ban books by introducing a spirit of fear among librarians and county and school workers that simultaneously erodes personal freedom and, respectfully disagreeing with the representative, weakens parental oversight. The Park County Library in Cody is the heartbeat of our community, and it is a trusted temple of learning. Its leaders, our librarians, community priests, if you will, are wise and well-trained. At the library, my husband, sitting here in the front row, volunteers in the children's library for a children's librarian-sponsored Rummy Cube game for our homeschoolers that supports math learning and social skills. At the library, he plays bridge 3 times a week, at least, in a cafe that is staffed by adults with disabilities. At the library, I spent a day a week writing my dissertation, and I continue to use its quiet space to work on my sermons. At the library, our precious only daughter freely sought librarian guidance as she read her way through all sections of the library. And her librarians were free to recommend both classic literature and scientific texts without fear of prosecution. At the library, she regularly found a haven from peer pressure and bullying. At the library, there has never been a single moment in our 19 years in Cody, Wyoming, that we have felt in any way unsafe. So I invite you, before you vote, to think about your own experience in your local Wyoming library and your relationship with your local librarians. And if you don't have such experience or such relationships to draw upon, I would ask that you lay this bill down and build those relationships and seek that experience during the interim time. This is a sneak attempt to restrict the right to read, representing government overreach in search of a problem that does not exist. I would support inserting something like the Miller test definition, which would confront a culture of fear arising from a he said, she said local set of allegations against our trusted and beloved librarians. Thank you. I am no expert, but I would take questions on my experience should you have any.
Thank you for coming all the way from Park County. Appreciate that.
Thank you, Chairman Washington. And thank you for all the work you've done on this bill.
We've got about 13 minutes left. Lots of people in the room, so. Good morning.
Good morning, Chairman Washit, members of the committee. My name is Lindsay Travis, and I am the past president of the Wyoming Library Association and the director of the Sweetwater County Library System. I respectfully urge a no vote on House Bill 10. Public libraries in Wyoming are governed locally by locally appointed boards made up of community members. These boards put time, thought, and careful consideration into crafting and implementing library policies that best fit and reflect the counties that they serve. For example, in Sweetwater County, we are currently reworking our library card and lending policy, a process that began last fall and is on this month's board agenda for possible approval. Library policies are adopted during public meetings following a waiting period that allows community members to review the proposed policies and provide public comment. Policies are also reviewed and revised following the same process to reflect current times and changes in the community. Library policies are not one size fits all. Even in Wyoming, community standards vary. A policy, for example, that fits in Sweetwater County might not be right for Albany County or Teton counties. Policies are best when they are locally driven, and these local policies work. For example, in Sweetwater County, we recently received 3 requests for reconsideration of library materials. After receiving these requests, we followed a process to evaluate all 3 books based on criteria outlined in the board-approved library collection development policy. The review process was thorough and unbiased. We found that one of the challenge materials did not meet the criteria to remain shelved in the young adult section. So we rectified the situation and moved that material to the adult section. House Bill 10 would undermine the work that local library boards do. While the bill would require the use of the library's reconsideration policy, the state-defined standards would automatically override local policies because if a book is not moved because the definitions are not read the same way, a patron would be able to sue the library. This removes the flexibility of local boards to serve the unique needs of their communities. Libraries in Wyoming are strong because they are governed by community members. House Bill 10 would significantly diminish local control of libraries and their ability to make decisions that reflect their own community values and circumstances. Government that is close to the people is effective. Local boards know their counties and do not need a statewide litigation-enforced solution for local policies. I urge the committee to respect the work of the local library boards and vote no to House Bill 10. Thank you.
Thank you. Next.
Hello, my name is Dylan Power. I am a high school student from Park County 6. I am with the Wyoming Behavioral Health Alliance. Honorable Chairman and Representatives, many of the points that I was going to make have already been said, so I will keep this short. This bill leaves no room for context or nuance. In 2024, John Green's Looking for Alaska became the second most banned book in the country. In response, Green said this: in the novel, teenagers engage in self-destructive behaviors because books don't exist to be moral screeds. They exist to be tellers of truths, and those things are real. The book is banned because of a one-page scene in which two teenagers engage in oral sex. Except it isn't pornography because pornography is designed to arouse. This scene is awkward and uncomfortable and funny and definitely unsexy. The language is cold and clinical. There is exactly one description adjective in the entire scene, and that adjective is nervous. Looking for Alaska depicts real adolescent experiences. What this bill does is label all depictions of sex as pornographic when it simply isn't. Much of what has the potential to be moved will be vital information, provide young adults with stories different from their own, which they can learn from, or stories that communicate to isolated youth that they are not alone. The bill will put resources like Looking for Alaska next to 50 Shades of Grey. In the same way that hunter safety is a valuable resource for anyone who will have exposure to firearms, these books and resources serve to support families and children across the state. By labeling them the same, we leave room to cause potential harm when children and families go looking for other resources. Thank you.
Appreciate you being involved. Thank you, sir. And I will say that we're going to go online. We've got a few people. We're going to take at least one of those folks online after this testimony. Sir.
Chairman, I'm George Powers. I'm a parent here in Laramie County, and I also oppose this bill. I believe that local solutions are the best for local issues. And in Laramie County, the school districts and the library have both taken action to address issues regarding the content of those libraries. And in doing so, the school district has provided us with some interesting information, interesting statistics that demonstrate what people in Laramie County believe about their libraries. The Laramie County School District has adopted a program which doesn't segregate books, but they classifies them. And if the books are designated as sexually explicit, parents can opt out and use their right to not have their children have access to those books in the school libraries. However, when you look at what parents have actually selected in Laramie County, the breakout is 62% of students have open access to the library. 38% have the more limited access. Now, that's an overwhelming majority. of people who have selected open access, the rights of those parents to select what their children will see will be impacted by this bill, because books that are in the school libraries, they're going to be removed. This bill will remove them, because if they aren't removed, those schools are going to be sued. So anyone who says that this bill does not censor is fooling themselves. Those books in school libraries will be censored and removed. Another flaw in this bill is that it treats 17-year-olds, 16-year-olds the same as 6-year-olds. And ladies and gentlemen, Mr. Chairman, I submit to you that anyone who thinks that a teenager of 16 and 17 has no greater capacity to deal with issues than a 6-year-old is fooling themselves. That is in fact reflected in the statistics from the school district, because when you track the percentages from the grade schools, 6 through K, and the junior high and the senior high, you find that in the high schools, the parents of high school students have favored open access by a margin of 75 to 25. Now, this bill does not recognize that. Now, the rights of those parents should be respected, yet this bill will take away their right, because those books will be removed from the school libraries. Their children will be denied that access. I respectfully urge this committee to consider what parents have actually done. And please vote this bill down. Thank you. If there are any questions, I'll stand for them.
Thank you, sir. Pierre, can we bring in someone from online? Representative Webb.
Thank you, Mr. Chairman. My question to the gentleman would be, and I appreciate you being here, was where did those statistics come from? Are they documented?
I apologize.
Sir, do we have documentation of where those statistics came from?
Those statistics came directly from Laramie County School District number 1. I would be, I tried to print them off so that I could bring them today. However, when I looked, the printer had been stocked with paper that had been used.
We understand. Thank you.
And so therefore I could not.
We need to move on.
I would
Sir,
be happy to
please do.
supply them.
Please do, but we need to move. We're about out of time.
I will get those to the committee
Thank you.
as soon as I can.
Pierre, would you bring someone in from online, whichever one's up? Carol Chidsey. Good morning. Can you hear us?
Yes, I can. Can you hear me?
All right, I can. You're going to probably be our last witness this morning. We have a hard break at 9:45, so the committee will have time to work the bill. So please be on point and brief.
This is very short. I am strongly opposed to this bill. It takes local control out of each of Wyoming's 23 counties and instead gives more power to the state government. The communities across Wyoming are unique. Afton is not like Ranchester, and Gillette has a different vibe from Rollins. Each community treasures its identity. State control over library materials strips that away. What library visitors want here in Lander to have available is probably different from that of patrons in Lyman. Our librarians are dedicated to find the right books that speak to the identity of the community. They know better than our state legislators what is appropriate for their towns, children, and families. Today, right now, if there's something I am upset with in our library, I can go to the librarian, then the library board, and finally the county commissioners. Do the legislators on this committee not trust our local county commissioners to listen to me and my neighbors? Do they think they know better than the local officials what books we want available to our children? This bill strips away that local control and gives it instead to Cheyenne. It is a perfect example of excessive government overreach, an accusation our legislators frequently direct at Washington. To protect Wyoming communities, maintain local identities, I urge you to vote no on this bill. Thank you.
Thank you. Questions, Ms. Jitsi? Okay, we're at 9:45. I'm going to close public comment. I apologize. It's one of those situations where in a budget session, you only have so much time. So committee, what's your preference? Moved by Lane, second by Webb. Do we have any amendments? Representative Chesty.
Thank you, Mr. Chairman. And with due regard to the earlier comments that amending a bad bill doesn't make it a good bill, I do feel like I should address, I have a lot of problems with this bill. And I'm going to vote against it ultimately, but there's one major problem that I think we can address that makes it slightly less bad. And that is, I've distributed it to members of the committee, and it deals with the definition of children's section. That's on page 2, lines 10 and 11. The problem with this definition is children's section means a portion of a library devoted primarily to or that provides materials aimed towards persons younger than age 18. My amendment strikes the words or that provides materials aimed towards. The reason for that is including that in the definition of children's section means that as soon as you move, so the children's section has books in it that are aimed towards persons younger than 18. And if they have sexually explicit materials, they're going to violate the statute. What the statute says is you can't display them in the children's section. So the suggestion has been you move them to another section of the library. But as soon as you move them to another section of the library, that section becomes a children's section by the definition, the explicit words of this definition. So basically that turns this into a complete ban of the book. You can't even have it in the adult section because when the adult section houses a book that is aimed towards a person under 18, that's now a children's section of the library and it is banned. So all I'm doing is removing the words or that provides materials. That's a very clean way to make sure that you don't inadvertently turn the entire library into a children's section. That's my amendment.
The second to that amendment? I think I'll second it for discussion purposes. Members at our last meeting, this came up. I think it's a valid concern that if you move some of this material to another section of the library, but that material is still aimed toward young people, then that becomes defined within that definition, it becomes problematic. So I think the amendment is needed. That's my position. Any other comments on it? Representative Lean?
Thank you, Mr. Chairman. The word primarily plays a big role there, and we covered this in our earlier interim committees. And there is another amendment to come that we have printed before us, and I believe that if we were to adopt that would take this and correct what is wrong with it.
Representative Bratton.
Thank you, Mr. Chairman. I agree that this issue was raised up in the interim committee, and I went to our LSO lawyers and asked how they advised to fix this. That's why there is another amendment. They both address the same issue. Not being an attorney myself, I don't know which of these is the best solution, but agree that we should adopt one of these. So, thank you.
With that, all those in favor of the representative's amendment, line 11 and 12 on page 2, say aye. Aye. Those opposed, no.
No.
That fails. Do you have any other amendments? Representative Bratton.
Thank you, Mr. Chairman. I move the second proposed amendment on page 2, line 11, after or that, to insert primarily. And then again on page 4, line 7, after or that, insert primarily. And my understanding from Brian Fuller, our LSO lawyer, was that that would be the belts and suspenders that would ensure that the entire library would not become a children's section, and that we could move items that should be in the adult section to
Is
another
there a second?
location. Thank you.
Second by Vice Chair. So let's go over that amendment one more time. We're on page 2, line 11, delete primarily. Is that what the?
No.
No, we're gonna add primarily where?
So on page 2, line 11, after or that, in the second part of that clause, insert primarily.
Okay.
And then again on page 4, line 7.
Line 7, same thing.
Correct.
Pierre, do you have that? Okay. Committee, any discussion on the amendment? Representative Chestick?
Thank you, Mr. Chairman. While I appreciate the effort to address the same problem that I addressed in my amendment, I don't think this is the better amendment. I think this is more confusing. The problem that I'm seeing is now the section, if this amendment is adopted, the section reads, the definition of children's section will be any portion of a library devoted primarily to or that primarily provides materials aimed towards. So we have two primarilies in that sentence. And primarily to me seemed like a singular thing. It's either, this is primary. If that's primary, nothing else can be primary. So by adding two primarilies in that sentence, I'm very confused by what it means. I think my amendment was clean. It just got rid of the basic problem. I'm also not sure we need the change on section on page 4, because that's talking about the adult section. So I will vote no, only because I think this is not as clean an amendment, and it's a more confusing amendment than the one that I proposed.
Further discussion, Representative Bratton.
Thank you, Mr. Chairman. If this amendment were to pass, I would be happy to go with Representative Chestick to Legislative Services to look at, to address those concerns and make sure that we do this in the cleanest and best way.
Representative Lee.
Thank you, Mr. Chairman. As I read this section, it means any portion of the library devoted primarily to children, right? Or any portion that provides materials aimed towards persons younger than 18. So those displays that you see when you come into the library would be materials that are aimed towards those that are 18. So I see it as there's two sections being covered here. So primarily just gives us the ability to say that if it is predominantly geared towards those that are 18 and over and the section of the library.
Thank you. Further discussion? Saying none, committee, you know what we're voting on? Everybody clear? All those in favor of the amendment, say aye.
Aye.
Those opposed, no.
No.
That amendment has passed. Further amendments? Any further amendments? Seeing none, let's have a roll call on House Bill. Representative Chestick.
This is a matter of discussion. I just wanted to say that I completely agree with all of the testimony we heard today. I also agree with the 500 emails I've gotten that oppose this bill. My problem with the bill is that it deprives parental rights. It says one set of parents or one set of community members, whether they're parents or not, can tell other parents how to raise their kids. And it's taking away parental control, parental rights, and it is a form of censorship. And for that reason, I am going to be a very strong no on this bill.
Representative Ling.
Thank you, Mr. Chairman. In 1957, the Supreme Court ruled that obscene materials are excluded from the First Amendment. We have a constitutional obligation to look out for the morality of the people of Wyoming. I hear that the librarians that the libraries already have a challenge process, so why the pushback on codifying this into law? Please, if you haven't read the definitions on pages 2 and 3 that outline what obscene materials are, please do so. And this bill allows for counties to still individualize the books that are purchased. It just requires where we shelve them if they have obscene content in them. Policy is not about emotion. Policy is meant to be good policy to look out for the people of Wyoming.
Further discussion? Representative Bratton.
Thank you, Mr. Chairman. This bill does not remove themes. I heard there was a statement that the Wyoming libraries do not have pornography in them, and I disagree. A graphic novel with a picture of a child performing oral sex on an older individual should not be in the children's section, and that is in some of our libraries. I don't believe in most cases, the community standard would vary on that. And I think something like that, there is a line, and that should not be in the children's section. So I do appreciate all the input that we've had on this bill. Thank you.
Representative Brady.
Thank you, Chairman. I was just going to say to the other representative who mentioned the emails, I would assume he's on the other, also on the email chains that are representing and supporting this bill as well. And also that it absolutely does support parental rights. It's not taking them away. So I'm for this bill. Thank you.
Okay. All right. Pierre?
I just want to state that LSO has no opinion on the merits of the amendments that are presented to the committee.
So noted. All right, let's call roll on House Bill 10. We have to be on the floor in 4 minutes.
Representative Brady,
Aye.
Representative Bratton,
Aye.
Representative Chestek,
No.
Representative Filer,
Excused.
Representative Kelly,
Excused.
Representative Lean,
Aye.
Representative Singh,
Aye.
Representative Webb,
Aye.
Chairman Washut.
Aye.
6 ayes, 1 no, 2 excused.
Thank you very much. All right, members, we are adjourned until Friday morning. This is Friday morning, till Monday morning.